Welcome to the Hennepin County Bar Association's Rule of Law podcast series, conversations with judges, lawyers, and legal scholars about the principles that form the foundation of our democracy. Each episode is hosted by a leader of the HCBA and explores what the rule of law means, why it matters, and how members of the legal profession can help protect it in a time of challenge and change. Thank you for joining us as we work together to strengthen justice and preserve the rule of law.
Hello, everyone. I'm Boulette, immediate past president of the Hennepin County Bar Association, and I'm joined today by Kat Rohn, executive director of OutFront, Minnesota, to discuss the Chiles versus Salazar case currently pending before the United States Supreme Court. Welcome, Kat. Thank you so much for joining us. Could you just start by telling our listeners who might not know OutFront's work a little bit about you and what you do?
For sure. So Kat Rohn, they and she pronouns. I'm the executive director of OutFront, Minnesota, which is our state's largest LGBTQ advocacy organization. We were founded back in 1987 at the sort of height of the HIV/AIDS crisis as a way to organize community power and, build structures and systems that would help, engage our communities in making change. And, we've done that ever since. We've gone through a couple different name changes and, different shifts in organizational focus. But today, our organization does a number of different things. So we do work around policy and advocacy and organizing within communities. We work in K through 12 schools, supporting educators, supporting LGBTQ youth and GSAs. And then we do direct client assistance work, particularly with folks who have been victimized based on, violence and discrimination, like domestic violence and things around LGBTQ identity. So we do a whole lot of work that sort of ties into that idea of caring for our communities, advancing change in both policy and culture.
Yeah. Well, and thank you for all that work that you're doing. So we're here to talk about Chiles versus Salazar, the United States Supreme Court case, and this has been big on my radar, I'm sure even bigger on yours, but a lot of HCBA members might not be familiar with this case or what it is or what it's doing. Would you mind just a little bit of background just to orient us?
Yeah, the short version of this case is that it is a challenge to Colorado's ban on the discredited practice of so-called conversion therapy. Colorado, like the state of Minnesota, has a law on the books that prevents folks from engaging in practices that would seek to change somebody's gender identity or sexual orientation, or at least claim to do that. These kind of practices, most widely known as conversion therapy, but they go under a number of different names, have for a long time been, discredited as not medical care, as not therapeutic care, and as having no efficacy in actually changing somebody's gender identity or sexual orientation. But folks like the plaintiff in Colorado are arguing that these restrictions, these bans on this type of therapy infringe upon their First Amendment rights, and that, the ban, like the one we have here in Minnesota, would be infringing on those rights to speak openly with a client about whatever, therapeutic recommendations or practices or whatever they might entail. So that's the case in front of the Supreme Court. It's worked its way up. There have been a number of challenges around the country to different conversion therapy bans. Each of the bans is worded slightly differently and has been around for different periods of time. Minnesota's is relatively new, but this is the first case that is taking this particular issue all the way up to the Supreme Court.
Okay. And so my memory of the case is that our plaintiff here is a therapist who, and I read, wants to provide, has been asked to provide conversion therapy in some setting. I feel like there was some ambiguity in the case around whether this plaintiff actually was doing the practice or had an interest in doing the practice that was prohibited.
Yeah, my understanding is that the practice is not happening, but they have potential interest in potentially offering this to potential clients who might be potentially interested in these types of conversations. And so there are a lot of speculatives. I think one of the big questions running into the initial case itself was was there enough standing to actually hear the case? And clearly the Supreme Court thought so. I think there's a lot of folks who are skeptical that this was essentially just a Trojan horse to get this particular argument in front of that body.
So I want to step back a little bit just to orient folks, because conversion therapy carries a lot of meaning and a lot of weight. But on the surface, it people might not understand, particularly people who haven't been impacted by it, the harm that's inherent. So you talked about conversion therapy as being therapy is designed to help. Therapy is designed to misalign somebody's sexuality or their gender identity. Can you just like a little bit of a brief history of what conversion therapy has looked like, how it's evolved, and why it's so harmful that so many states have moved to prohibit it?
For sure. So up until about 1973, LGBTQ identity broadly was classified as a mental disorder. And so many psychiatrists, psychologists, folks within the mental health profession sought to resolve people's conflicts about their gender identity or sexual orientation through change efforts. And unfortunately, especially during that time period, and even running up through fairly recent time periods, folks would engage in really harmful and obviously just wrong practices, including things that were like, these sort of aversive therapy practices, electroconvulsive therapy, like, intentionally causing people pain or causing nausea or things like that to try and cure, quote unquote, people of their, perceived gender identity or sexual orientation. And, those practices went out of favor and were banned for all sorts of reasons. Many of them, were just illegal under other current therapeutic practice standards because of the harm that they inflicted in people. And folks engaged in the conversion therapy space moved more into what they describe benignly as talk therapy. But effectively what these practitioners do are work with clients who some are there of their own volition and have concerns about their, perceived incongruence with their own identities. And some of them are there because a parent or a guardian or somebody else is forcing them to be there because of discomfort with their identity. And effectively, this quote unquote therapy, but effectively, coercive practice seeks to push these people into affirming an identity that may not actually be real for them. And all of the sort of, studies of this practice that have been done by, the American Psychological Association, American Medical Association, and others have demonstrated no actual efficacy. One of the core, foundational principles of treatment is that you actually have to demonstrate that it treat something, which one both calls into question, is there a condition here to be treated? While somebody might experience discomfort about their sexual orientation or gender identity, in a lot of cases, that's because of external conditions and pressures, not because there's anything inherently disordered with them. But beyond that, the actual practices themselves have not been shown to lastingly change people's sexual orientation or gender identity, and often lead to really negative outcomes of shame and potential for things like higher rates of substance abuse or self-harm later in life. And particularly for youth who are not able to fully consent to these practices, it's really important and essential that they're protected from those potential harms that we know and have demonstrated to be true, even when we're talking about things like talk therapy.
And that was going to be, part of kind of the next extension of my question is I remember when I was growing up, maybe when you were growing up, there was the fun, campy, but I'm a cheerleader conversion therapy. And it wasn't fun. And it wasn't just ineffective at changing people's identities. It did real harm. And so, I know Minnesota, we have our own ban on conversion therapy. What is the harm, though? So if I am sent into conversion therapy, particularly as a teen or a kid, what is the harm that we see coming from conversion therapy beyond just that gay people stay gay, trans people stay trans at the end of it?
Yeah, I think the most fundamental harm is that it creates a disconnect for somebody between their identity and their lived experience in the world. For somebody who is pushed into this, particularly for a child who may want to come to some understanding about who they are and be recognized, to have a loved one, a caregiver, demand that they go to this or enroll them into these types of, treatments, whatever you want to term them as, is a breach of trust with somebody who is supposed to care for them and affirm them and support them for who they are and love them for who they are. And that can cause all of these sort of ripples down the line for them. One, it can create these barriers for them around their own relationships with their family or whomever might have pressured or pushed them into these particular treatment modalities. And down the line, that sense of shame and that sense of misalignment can cause real harm for their ability to form relationships, for their ability to process and seek help around any of the relationship challenges they might have, whether that's romantic or familial or other. And it can delay their process of being able to come out and live fully as themselves and enter into relationships that are fulfilling and meaningful, or to enter into a gender identity as a lived experience that is fulfilling and meaningful. And I think all of those pieces we see in the experiences of folks who have gone through any of these practices and have identified themselves as survivors. For some of them, that meant very real harm, and sometimes these practices were paired with abuse from folks in their lives who thought that they needed to change. And for some folks, it was just a really delayed process of then being able to really fully come into themselves. And that loss of time of life fully lived is something that folks then have to live with for the rest of their lives.
Yeah, it's a very real harm that I think can be hard to understand, right? To that self-denial that carries through a significant portion of your life while other people are doing their own, living into their adult selves. When we talk about a conversion therapy ban, though, I want to understand the structure of this a little bit more, because we have clearly what's not against the law, right, is any old person for any old reason saying, I don't believe trans people exist, or I don't believe you, particular kid, are really queer. What is the kind of, what are laws aiming at when they're banning conversion therapy? What's the kind of structure that says you can't provide this particular service?
Yeah, I mean, I can speak to Minnesota specifically because we had a very long journey to arrive at the ban that we now currently have on the books and in place. Minnesota's conversion therapy ban, which was passed in 2023, came after about 9 years worth of advocacy around this issue that started in the early 2010s around the country, but in Minnesota specifically in the early 2010s, led to a number of different municipalities placing restrictions on, the sorts of treatments that could be offered within their boundaries, and then eventually leading to an executive order signed by Governor Walz in 2021, and then the passage of the state's conversion therapy ban in 2023. And there's really two things that the ban seeks to do. One, and I think it's really important to note, the ban is specific to conversion therapy practices that are aimed at youth and vulnerable adults. So, we really recognize that adults who are able to make, full consenting decisions to enter into whatever care modalities they see fit for themselves can do so. And there's no restrictions on that, or no restrictions on somebody who wishes to provide these services to, somebody over the age of 18 who can consent to them. The other thing that it does is it very specifically is limited to folks who are licensed practitioners. So, there are all sorts of folks who may have conversations, may have even therapeutic conversations to a degree with folks, particularly in ministerial spaces and religious spaces. And our ban was very explicit about making sure that those folks can continue to have those faith-based conversations, but not do that under the umbrella of a licensed medical practice. What we wanted to make sure is that licensed medical practice in the state of Minnesota was following actual medical standards and best practice. And then the final piece that Minnesota's ban encompasses is advertisement of services. So we don't want folks advertising services and misleading folks into believing that these might be a cure or a help to somebody who's seeking them out. And so, our provision is very narrow, and many of those pieces were carefully worked on, which is why it was able to pass with bipartisan support from folks who believed, as did, the advocates in our bill, that these were simply harmful, unwarranted practices that should not be widely accessible and certainly shouldn't be accessible to youth.
And so when we talk about a conversion therapy ban, we're not talking about you're going to go to jail if you provide conversion therapy. We're talking about it would be professional misconduct for a licensed social worker or a licensed marriage and family therapist to provide a therapy that is proven to be not just ineffective, but harmful in some instances.
Yeah, correct. So there's no criminal penalties here, but there could be a complaint process initiated if somebody's engaged in these practice in violation of the, statute that's there. And so, again, it's really about just sort of dissuading what we already hope is a very limited and, minor practice within the state of Minnesota.
And so if I try to graft that onto Chiles versus Salazar, acknowledging that it's not the Minnesota statute there, but the Colorado one, it seems like what the state would say is, well, what we've really done is just pass a law banning an ineffective form of treatment that also causes harm, right? If we wanted to pass a law that banned phrenology because not only does it not work, but you're lumping people on the head, that's part of what states do every day when we regulate certain kinds of practice or not. What's the plaintiff say? You mentioned a First Amendment claim, but what's the right to free speech this plaintiff says is implicated?
Right. So I think, this is one of the central pieces that the Supreme Court is weighing around this case, and that's the question of whether talk itself is therapeutic practice or whether it is always just conversation, in which case, is this a question about free speech or is this a question about regulating medical practice? The Supreme Court has clearly found, and, unfortunately, as they did in the Scrimeti case, that states have the right to maintain laws and rules around medical practice within their borders that they see fit to, care for folks. In this case, the argument that the plaintiff and their side is making is that this is not about regulating practice, it's about regulating speech, and that inherently by restricting this type of speech because it is a practice, that you are limiting this person's right to free speech and free expression.
Now, when we think about Chiles versus Salazar, it's definitely been a topic of conversation in our community. When you think of the public at large, are there any misconceptions you think are kind of prevalent in popular media that it would be important to dispel?
Yeah, I think there's a couple different prevalent misconceptions about conversion therapy in general. One is that it's gone away. And I think, the good news for folks is that because of all of both the advocacy work, but also some of the legal work around this, that the most egregious forms of conversion therapy are nowhere near as prevalent as they were in the early 1990s. However, those things are still present and those pressures are still present on many folks within our communities, and the impacts of them are long lasting in people's lives. And so, I think when we think about things like conversion therapy, it's easy to talk about it as if it's a historical artifact when in fact it is a real and current practice, and one that we have seen, current sort of right-wing advocates trying to push into advocacy around what they believe to be appropriate treatments for things like gender identity writ large. And so, I think recognizing that it's real and happening here in Minnesota is really important. I think the other misconception here is, again, that idea of, laws trying to really infringe on people's rights. And I think it's really important, within the context of, all of the discussions that are happening around LGBTQ care and freedoms and expression and things like that, to be really clear about where are those lines. And I think, one of the misconceptions is, yes, people have a right to free speech. This plaintiff can talk about these practices outside of a clinical setting as much as they want. But inside of those regulated clinical settings, we're talking about a very different set of arguments. And, I think that, hopefully can move people away from those sort of, well, you're really controlling what people can say and do. We control people's actions and their speech all the time through all sorts of employment practices, through all sorts of regulations about how we engage in different conduct. And this is really no different than that, in my view.
Right. That conversion therapy bans are not asking everybody in the state to accept gender identity or sexuality in the way that you or I might understand it. It is asking that folks who are licensed professionals adhere to licensed professional standards of care.
Bingo.
Now, you talked about conversion therapy as not being a historic artifact. And I think this is a really important point because in conversations I've had, there is that sense that conversion therapy was a thing we used to do. And we used to do it in especially scary ways, when maybe you and I were infants, and we did it in still pretty problematic and messed up ways when, you and I were teens and young adults, but that's not something people do anymore. Maybe it happens with a pastor in a church, maybe it happens as part of a religious tradition, but there aren't actually social workers and mental health care professionals out there trying to change around people's gender identity. But I was reading just this week that kind of new terms are coming into fashion so that it might not be conversion therapy anymore. It might be gender exploratory therapy now, or new kind of ways of doing the same old thing, but under a kind of updated guises. What, in your capacity in OutFront, what are you seeing as kind of the real on-the-ground practices where bans like this continue to matter in the lives of LGBTQ Minnesotans?
Yeah, I think, we see terminology like exploratory therapy or reparative therapy as kind of like these kind of more like rebranded marketing terms for these same sorts of practices that are seeking to change people's gender identity and sexual orientation fundamentally. And I think, the importance of the bans, and, this is true of many laws, is not that the ban itself will totally prevent or get rid of the practice, but it is about trying to create conditions where it's harder and harder for those folks to take advantage of people who cannot consent to these actions. And I think, that is really the important goal that was, driving our push for the ban here in Minnesota. I can't control every conversation that people are going to have around this. Folks have a broad range of opinions about gender identity and sexual orientation, and that's okay. We don't need to control that. But we want to make sure that when folks step into those clinical settings, that they trust that the care they're getting is good care and appropriate care. And I think, the goal here is to place that barrier so that it is less and less likely that somebody would go into that setting thinking they are doing right by themselves or their child, and then emerge out of that with a lifetime of trauma.
Now, I want to help our listeners situate the Salazar case both kind of at the local and the national. So we're here talking about Salazar, but of course, there's been a lot moving for LGBTQ folks nationally. How does the Salazar case fit into that broader landscape? You already mentioned Scrimeti, but what is kind of the national movement we should be thinking about as we understand where this fits beyond the case itself?
Yeah, I think there are sort of three salient lines of legal attack against the LGBTQ community writ large. One is around just access to healthcare broadly and who gets a say in determining access to healthcare. And that's come up in a number of cases. That is a sort of central question in Salazar, in addition to Scrimeti and a number of other cases out there. But, I think that comes down to like who fundamentally gets to make those choices and whether it is the government or families and care providers, and how do we weigh different medical science and different opinions about different types of care. I think the second piece is one that's not really present in this, but has come up a lot through conversion therapy ban conversations, which is around freedom of religion. And, folks who have strongly held religious beliefs about gender identity and sexual orientation, which, many religions have a full gamut of different beliefs and opinions about those topics. But for many folks, these sorts of bans and expansions of LGBTQ rights laws and non-discrimination laws have at least been perceived as infringing upon their religious beliefs and practices. And we've certainly seen that here in Minnesota with recent case law. And then I think the final piece is this question of speech and expression within the public forum. And, we have this come up in Salazar, but we also have this come up in a lot of cases when we're talking about either bans or challenges to policies around the use of pronouns or names and things like that, where folks are trying to argue that either the government is compelling them to speak in a certain way or that people shouldn't be speaking in a certain way because of beliefs around what is appropriate or real or whatever the case may be. And I think those sort of three angles touch on fundamental questions in all of our lives. Healthcare is important to all of us, regardless of whether we're talking about LGBTQ rights, as is freedom to and freedom from religion and speech.
Yeah, and that's really interesting because there are so many recent cases that get at all three of those points, right? It was the Ohio case that ended up at the Federal Court of Appeals. Can states pass, or can school districts require students' pronouns and correct name to be used? That resulted in, I think, in a holding of unconstitutionality. You mentioned a case in Minnesota that just came down that an employee of a Catholic school could be discharged because of a transgender identity, even though she worked in a wholly secular role. And do you see a lot of cross-pollination between the thinking happening in one setting transferring over to another? How do you see those conversations crossing each other?
I think in a lot of ways, it's mostly like throwing as much as you can at the wall to see what sticks. There are just folks who are looking to erode LGBTQ rights and access to care and ability to exist within the public sphere writ large. These folks are looking to reverse all of these gains made over 50 years and say, look, it was a better time when LGBTQ folks weren't in my public life and public existence and public sphere. They were there. We all know that. We know our history. But, I think that is the end goal. And what they're doing is attempting to use all of these different constitutional arguments and tools to try and erode the different protections and care options that we've built up over many decades, just as they are trying to pass, literally this year, I think we crossed the 1,000 bill mark in state legislators around anti-LGBTQ legislation. So it's all of these attempts to roll back and strip out and push out all of these protections because of this perception that greater recognition and support has somehow infringed on somebody else's right to live.
And it really is, I think, important to see it in that both and context, that for folks who perhaps looked at the Scrimeti decision that allowed states to ban gender-affirming care for minors and said, well, reasonable minds can disagree, there is one constitutional line of attack that allows states to pass laws that might discriminate or disadvantage. But a case like Salazar goes a step further and really takes aim at policies like those in Minnesota, saying, even if you want to add those additional layers of protection and you have through the democratic process, maybe you can't. And we're going to not just allow states that want to erode rights, we're going to compel states that have tried to protect rights not to do so. With that said, though, I do want to zoom in, because we zoomed out to talk about the national setting. When you think about what's going on in Minnesota, how would Salazar and cases around it impact the work you're doing in Minnesota and impact LGBTQ plus Minnesotans?
I mean, I think some of it depends on outcome, and the Supreme Court could obviously rule in a number of different ways or, kick this ruling back down for further review. So there's a lot of different directions that this could potentially go. But I think what we have to prepare for in Minnesota and Colorado and elsewhere is the possibility that conversion therapy bans that have been enacted over the last decade may no longer be enforceable, may no longer be seen as constitutionally allowable. And I think, that's a huge loss and a tremendous loss to the many victims of conversion therapy who have spoken out and testified about their experiences and have worked tirelessly to try and advance these bans to repair and protect future generations from that same harm. But I also think that as much as law is a really important tool in this particular setting, I think in some ways the biggest part of that battle has already been won. We have moved the cultural conversation through these conversations about policies to a point at which not only are the folks practicing conversion therapy not doing so in public settings, in public eye in the same way that they were a decade or two ago, but the stigma and the questions around it has grown to the point at which families and individuals are less likely to seek it out because they understand now the impacts and the harms that it can cause. And I think as long as we keep those cultural narratives strong and continue to push on ways to ensure that it remains on the fringe rather than sort of inviting it back into mainstream medical practice, it will remain a really marginal part of the environment that we have to deal with. And I don't say that because it, prevents harm, but I say that as a way to, sort of recognize the impact of policy on the cultural conversation and the fact that we saw 11 Republicans in the Minnesota House and 2 Republicans in the Minnesota Senate support our bill, tells me that the cultural conversation about this issue has moved from where it was a decade ago. This is not an issue that is just about partisan lines or about a particular set of circumstances or a small community. It's about people coming together and saying, we want to make sure our kids are safe. And I think that cultural piece will continue regardless of how the Supreme Court rules, and we'll just have to be all the more vigilant and all the more communicative with folks in our lives about the real harms that are still out there, and just recognize that the law may not be enough to protect us.
You talk about communication, and I love that because the HCBA is the largest local bar association in Minnesota. So lots and lots of lawyers who I suspect sit around tables and at get-togethers and get a lot of questions from non-lawyers about what does this mean? What's going on? I saw this article. How would you suggest, or how do you think lawyers can promote kind of clear, thoughtful conversations about Salazar and really cases implicating queer rights generally in ways that can help educate the public and avoid misinformation?
Yeah, I think, one, it's really important to put these laws and these Supreme Court rulings and hearings and decisions in the context of the process and in the context of the impacts that they have. So a decision like Scrimeti around gender-affirming care had widespread implications for a lot of states. Ironically, in some ways, it maybe solidifies the case for Minnesota to maintain and protect our access to care because of the nature of the decision. I don't think it was a good decision, but I think that, we can be thoughtful about how we talk about it and talk about its impacts. For Minnesotans, that didn't change our care environment, but it did change the care environment and solidified the patchwork environment that we live in. I think with Salazar and with other cases around these sort of conversion therapy bans, I think it's really important to note, what we're talking about is regulation of practice. And there are always different ways to regulate practice. So there will still be ways for us to regulate misconduct in practice, to regulate harm, to think about liability, to think about all those things. So if there are people who are really trying to actively take advantage of a landscape where these bans are no longer enforceable, there may be other tools that we can use that are really talking about practice and not about speech. Or there are simply ways we can utilize our voices and our advocacy and our work to make sure that people know about those harms and have access to better and efficacious healthcare resources. And I think, those are tools that, for folks who want to have a clean answer, it's nice to have a law that just stops the thing that you don't want. But we recognize that the law has its limits. And I think for lawyers, being honest about what can the law do and where can we go with it when it fails us or fails communities is really important, because the way I see it, it's like we can take all of these different tools, but the end goal is to build greater equality and inclusion for everybody. The law is one of those tools, but it's only one. It's not the sole tool we can use to make change.
This has been an amazing conversation, and I know there are going to be a lot of listeners who want to know what comes next, how they can learn more, how they can follow developments, and how they can support work like yours and OutFront. What would you recommend to those folks in terms of resources and in terms of action?
Yeah, I think, for one, plug into groups like OutFront Minnesota, like Gender Justice, like other LGBTQ advocacy groups here locally or those nationally. There are a lot of people doing really good and critical work at every level. And, this is one of a multitude of different issue areas that folks can engage around. I think on conversion therapy in specific, I know there are already a lot of conversations happening around the what might come next. So, if a decision comes down in May or June of this, coming year, what would we do as a state, as, localities to respond to that? And I think it's really important that folks who are passionate about this issue talk to their legislators, because we're already starting as an organization to have some of those conversations to say, what are the tools that are available to us should this no longer be the tool? And what can we do to continue to move towards a Minnesota where this practice no longer happens? And I think all of us can play a role in that.
Kat Rohn, thank you so much for joining us, and thank you everybody for listening.
Thanks for having me.